Successfully navigating complex debt structures requires a deep understanding of subordination, security interests, intercreditor agreements, priority rules, enforcement mechanisms, and cross-collateralization. Precision in drafting, thorough due diligence, and alignment with current legal and market practices are essential for protecting creditor rights and managing risk. Introduction. The foundations of subordination and security interests. Subordination and security interests are the backbone of modern debt structuring, determining who gets paid when and from which assets in both ordinary and distressed scenarios. In complex capital stacks often involving multiple lenders, facilities, and asset types, clear rules and robust documentation are critical to avoid disputes and maximize recoveries. Key legal concepts and frameworks. Senior debt holds the first claim on assets and repayment, while subordinated debt is paid only after senior obligations are satisfied. A security interest gives creditors legal rights in a debtor's property collateral to secure repayment, becoming enforceable through attachment and effective against third parties via perfection, e.g., public filing. Priority determines the order in which creditors' claims are satisfied from collateral or proceeds. Legal foundations. UCC Article 9 governs creation, attachment, perfection, and enforcement of security interests in personal property. Federal bankruptcy law enforces subordination agreements. Bankruptcy Code 510A sets claim priorities, sections 506, 507, and treats unperfected interests as subordinate to the bankruptcy estate. State law adopts UCC rules with minor variations, governs real property security interests, and some enforcement procedures. Subordination agreements, mechanics, and best practices. Subordination agreements include key provisions such as payment waterfalls to prioritize distributions, senior debt first, then subordinated, then equity, standstill clauses to restrict junior creditors from enforcing remedies after default, turnover provisions requiring juniors to remit improper payments to seniors, and amendment controls to prevent changes without affected creditors' consent. Best practice: use clear and explicit language as courts strictly interpret subordination and standstill clauses, particularly in bankruptcy. Enforcement and litigation. Subordination agreements are generally enforced as written, both in and out of bankruptcy, unless tainted by creditor misconduct. Remedies for breach include injunctive relief, damages, and turnover of payments. Intercreditor agreements. Managing multi-lender structures. Intercreditor agreements define the rights and priorities among multiple lenders in complex debt structures. Senior subordinated agreements govern relationships between senior and junior lenders, while first lien, second lien agreements allocate rights between lenders with different priority liens on the same assets. Mezzanine agreements address deeply subordinated claims or equity-secured lenders, and pari passu agreements ensure equal priority among lenders. These agreements are critical for clarity, enforceability, and minimizing disputes in multi-lender arrangements. Key provisions. Intercreditor agreements outline payment priorities, determining which creditors are paid first from collateral or bankruptcy proceeds. They define enforcement rights and include standstill clauses to delay junior creditors from acting. Voting and amendment rights specify who controls waivers, amendments, and enforcement actions. Bankruptcy provisions address control over DIP financing, asset sales, and plan objections. Key finding: LSDL model agreements and major law firm templates set market standards and provide a solid foundation for negotiations. Common negotiation points. Key issues in intercreditor negotiations include the duration of standstill periods, typically 90-180 days, during which junior creditors are barred from enforcement. Discussions often focus on the scope of junior creditor waivers in bankruptcy, conditions for collateral release or substitution, and junior creditors' rights to object or participate in DIP financing during bankruptcy proceedings. These points are critical to balancing creditor rights and ensuring enforceable agreements. Priority rules and enforcement mechanisms. Under UCC Article 9, priority is generally determined by the first-to-file or perfect rule. Though purchase money security interests, PMSEs can gain super priority if statutory conditions are met. Fixture filings address priority for goods attached to real property. In bankruptcy, secured claims are paid from collateral up to its value, with any excess treated as unsecured. Unsecured claims follow the Section 507 hierarchy, prioritizing administrative expenses, employee wages, and taxes. If assets are insufficient, creditors in the same class share distributions on a pro rata basis. Enforcement tools. Secured creditors can repossess collateral peacefully or through judicial action if necessary. Under the UCC, collateral must be sold in a commercially reasonable manner, with proceeds distributed by priority. In bankruptcy, the automatic stay halts enforcement, requiring creditors to seek adequate protection.